Debs County Court at law number 2 is now in session. Court is in session with its trial docket. First case that we have on the trial docket is cause number M329-864. Case is style of state of Texas versus Jimmy Lawrence Martin III. Mr. Martin, would you please come forward? You come around. Okay, this is cause number M329-864, case of style state of Texas versus Jimmy Lawrence Martin III. Mr. Martin, is that your full name?
Yes, sir.
How you doing, Mr. Martin?
I'm doing good.
That's good, Mr. Martin. You're here represented by your attorney, Attorney Donald Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
And state is represented in this case by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm doing well. Thank you.
Mr. Boudreaux, what is your announcement in Mr. Martin's
We're
case?
ready for trial.
State?
Thanks for it.
Okay, this is the number 1 case. Next case is cause number,
I'm so sorry to serve your honor. We're actually going to have a bench trial, or at least it's my understanding.
okay,
That's
well, that's fine.
Yes, sir.
Okay, let me call the next case. Next case is, where's Mr. Galmore?
He
Okay.
went in the back, Judge.
Hmm?
He went.
Oh, he's right there.
Oh,
Next case is cause number, y'all can have a seat. Cause number M321-566, case of style state of Texas versus Tyler Lindsey Connor. Mr. Connor, would you come forward? Is Mr. Next, this case is cause number M321-566, case of style of state of Texas versus Tyler Lindsey Connor. Mr. Connor, is that your full name?
Yes, sir.
How you doing, Mr. Connor?
Good. How are you, Judge?
I'm doing fine, thanks for asking. Mr. Connor, you're here represented by your attorney Dustin Galmore. Attorney Galmore, how you doing?
How you doing? Good, Judge. How you doing?
I'm doing fine. And the state is represented by attorney Kobe Hoffar. Attorney Hoffar, how you doing?
Good, Judge. Thank you.
Mr. Galmore, what is your announcement in Mr. Connor's case?
Ready.
State?
Ready.
Okay. Okay, this, the first trial is gonna be a bench trial, so this will be the number 1 case. And next case is called, y'all may be seated. Next case is cause number M330168 and cause number M330166. Both cases are style of state of Texas versus Victor Felipe Leon. Mr. Leon? Mr. Leon, your full name is Victor Felipe Leon.
correct, Your Honor.
Mr. Leon, how are you doing?
Doing good, sir. How are you?
I'm doing fine. Mr. Leon, you're represented in your case by Attorney Wright Kimler. Attorney Kimler, how are you doing?
Well, Your Honor, thank you.
And Mr. Kimler, what is your announcement?
Ready.
Okay, so this will be the number 2 case.
That's 2, so I guess, but I don't know.
Yeah, they'll be number, either one of
Which
them,
order they're gonna
number
go.
2. All right, Mr. Leon, you may have a seat. Next case is Russell Ryan Knapp.
No.
Mr. Knapp, your full name is Russell Ryan Knapp.
Yes, sir.
Okay, this is cause number 2 cases, cause number M330438 and cause number M330436. Both cases are style of state of Texas versus Russell Ryan Knapp. Mr. Knapp, how are you doing?
Good, sir. How about yourself?
I'm doing fine, thanks for asking. Mr. Knapp, you're representing your case by Attorney Kimler. Attorney Kimler, what's your announcement in Mr. Knapp's case?
Ready.
Okay, these cases will be the number 3 case, one of these cases, okay?
Okay, let's have a-
Yeah, see, next case is cause number M33290, case is style of state of Texas versus Hannah Marie Smith.
I think she was 4.
Ms. Smith, your full name is Hannah Marie Smith?
Yes, sir.
How you doing, Ms. Smith?
Good, how are you?
I'm doing fine. Thanks for asking, Ms. Smith. You have two cases, cause number M332156 and cause number M332090. Both cases are styled of state of Texas versus Hannah Marie Smith. And Mr. Kimler, what is your announcement of Ms. Smith's cases?
Ready?
Okay, these cases will be the number 4.
See.
Have a seat. Next case is Terrence Paul Mann. This is cause number M332754, case is styled of the state of Texas versus Terrence Carl Mann. Mr. Mann, is that your full name?
Yes, sir.
How you doing, Mr. Mann?
I'm doing fine. Thank you.
I'm doing fine, thanks for asking. Mr. Mann, you represented your case by attorney. All right, Attorney Kimler, what's your announcement of Mr. Mann's case?
Ready?
Ready.
Mr. Mann, this case will be the number 5 case. Yeah, okay. Now, yeah, you may have a seat. Now we need Mr. Boudreau and Mr. Martin and Mr. Johnson. Y'all ready for the bench trial? Jefferson County Court at Law is back in session and cause number M329864. The case is styled the state of Texas versus Jimmy Lawrence Martin III. We have Mr. Jimmy Lawrence Martin III who's present in court. Is that correct?
Yes, sir.
Mr. Martin is represented in this case by his attorney Don Boudreau, and the state is represented in this case by attorney Lamar Johnson. Now, Mr. Boudreau, is Mr. Martin waiving his right to have a jury trial in this case?
Yes, sir.
State, you also joining in with a waiver of jury trial?
Yes, Your Honor, state's waiving its right to a jury trial.
Okay. State, are you ready to proceed?
State's ready, Your Honor.
And defense, are you ready to proceed?
Yes, sir.
At this time, hold on a minute, Mr. Johnson.
Sir.
No, I was talking to Mr. Johnson. At this time, Mr. Johnson, you may proceed by reading the information.
Thank you, Your Honor. The information reads, in the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Jimmy Lawrence Martin III, hereafter styled the defendant, heretofore on or about May the 3rd, 2021, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Ayanna Hubbard, hereafter styled the complainant, by punching and kicking the complainant about the head and body. And at that time of the said assault, complainant was a member for the defendant's family against the peace and dignity of the state.
Mr. Martin, how do you plead, guilty or not guilty?
Not guilty.
Okay, Mr. Johnson, you may proceed. You'd like to have an opening statement?
No, Your Honor, the state waives its right to have an opening statement.
And Mr. Boudreau, you like to have an opening statement, or do you waive your right to have? An
We waive it, Your Honor.
Okay, Mr. Johnson, you may call your first witness.
Thank you, Your Honor. The state calls Ayanna Hubbard.
No response.
State, do you have any other witnesses?
No further witness, Your Honor, and the state rests.
Okay, Mr. Boudreaux, you have a motion?
Yes, sir. We would move that Mr. Martin be found not guilty.
Okay, court is gonna grant an instructive verdict in this case. At this time, Mr. Martin, you've been acquitted of these charges. Our court clerk will be, I'll be signing an order to that effect. Just have a seat, and we're gonna call you up when we get the judgment.
Yes, sir.
All right, just have a seat. Okay. Once we get the judgment, you and your attorney, Mr. Boudreaux, be free to go.
Yes, sir.
Yeah, I hope
Thank you,
that's
Judge.
safe.
Thank you.
You are. Okay, Miss. Do you have a judgment? Okay. Okay, Mr. You can come. And Mr. Connor, you can come in and have a seat with your attorney, and are you free to go? That's Mr. Boudreaux's phone. Okay. All other defendants can go outside. Is that door open over here? That's when as soon as we get started. Hmm? Yeah, I hadn't did it. You need me to sign it? No, that person is not here.
Regulation.
Yeah, well, we're gonna go to the court, Judge. I didn't file the jury option.
File motion. Probation.
No, he didn't do the judge.
That's right. Second room.
Yeah. Usually don't have to file, I think you can do it with the judge. My last trial, jury told me that we elected to give a jury for punishment, they would have convicted him pretty much immediately because they would have been in control of the punishment. But because we were gonna go to court,
Okay,
they didn't want to convict him.
yeah, the defendants staying outside and we can call in the jury.
Yeah, they did. Follow the instruction. It's supposed to be.
Yeah, you can. They're gonna give them their recess when they, we gonna go ahead and get started. I mean, you can go ahead and just do the reset.
Yeah.
In fact, all of them are represented based by Wright Kimball.
Yeah,
All of them represented by Wright Kimball.
either way. I need to sign them.
You don't have to sign it, you just have to. Did it, go through? Yeah, nothing went through.
We got everyone. Yeah.
Okay, State, are you ready?
Thanks for that.
Defense, are you ready?
I'm ready.
Mr. Bell, if you can call get the jury. And
Yeah, I do. I'm gonna use it for practice. It's done. Not as. Not even.
where's my list?
But I'm not good.
Don Pumper, please come up, each one past the wall. Ms. Pumper, you're gonna take the seat all the way on the end against the wall. Yeah. Nikki Leje, this lady will get that chair, the second chair. Susan Lewis will get the third chair. And Sean Prejean, you're gonna get that chair. Walker Holloman. Gonna pass that first set of chairs. Gonna take that chair all the way at the end with the black and yellow tape. Andrea Miller, follow Miss. We have Walker. And you're gonna take that chair, that black and yellow, with the black and yellow tape right there. Is that God Dome?
Yes.
You're gonna take that chair in the middle of that row right there, right where you just passed, the black and yellow tape. And so you're gonna take that chair against the wall. And that's Daniel Ward, is that correct?
Yes, sir.
Danny Baker, you're gonna stop right there. Walk all the way down that row, you're gonna get that chair against the wall in that row. And Mr. Baker is gonna be followed by Mr. Blitch. Yes, against the wall, and you're gonna do that second set of chairs, you're gonna get the chair with the black and yellow tape. And Mr. Christopher Jacobs, walk down the same aisle, you're gonna take that chair with the black and yellow tape on the end right there. And Mr. John Hill, that's your chair with the black and yellow tape. Scratch number 15.
Yes, sir.
Okay, Stephen Martinez, the aisle that you're on, you're gonna walk all the way down the chair on the end with the black and yellow tape. Britt Valente,
Yes, sir.
that's walk down that same aisle. You're gonna take the chair with the black and yellow tape on the end right there. Number 15 is not here. And so 16, Cheryl Williams, that's your chair right there. And that's Robert Womack.
Yes.
You're gonna be on that last aisle. And you're gonna walk to that second set of chairs with the black and yellow tape. Yes. Brianna Humphrey, that you stop right there. Walk down that road, you're gonna, that chair with the black and yellow tape near the picture, that's the chair you're gonna sit in. And Mr. Andrew Lee, the chair right by the wall, black and yellow tape. And Miss Renee Bourgeois, you're gonna sit in the chair against the wall. And Mr. Bailiff, you can show Lacey Boyd where you want her to sit. We need to put Mr. Bailiff, that white sheet of paper that's on the table with the tape on it, you could put it in chair number 15, which is already, yeah. State, are you ready?
Thanks, Judge.
Defense, are you ready?
Right, Judge.
Okay. Ladies and gentlemen of the panel, I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been called for jury service in a criminal case. You will be examined for inclusion on the jury in this criminal case. The criminal case is styled the State of Texas versus Tyler Lindsay Connor. Our courtroom hours vary. They are normally from 9 to 5 p.m. However, we usually have other cases in the morning between 9 and 12 o'clock. Therefore, we normally alter our hours for trials from 1:30 or from 1 o'clock to 5 p.m. Whether you are selected for inclusion on this trial, you are serving or performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate for recess, for meals, and at night. Now, I must administer the first of 2 administrative matters. The first matter that I must administer, I need to have everyone on the panel to raise their hand so I can administer to you the oath. And once I finish administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God? Okay, you may put your hands down. The law requires that each of you possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses or exemptions some of you may wish to claim. At this time, I would like to determine if you possess the qualifications for service on this criminal trial. It is very important that you answer these questions truthfully. If you do not, and the lawyer or I discover this fact after you are seated on the jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way that I will ask the questions, I will not ask the question to you individually. I will ask the question to you as a group, and I will just ask the question, but I just want you to answer to yourself. And then once I finish asking the last question, then I will ask you, is anyone disqualified under the law? And if you think that you are disqualified under the law based on the way you answered the question, then you would just simply, I would ask you to raise your right hand, and then we would ask that you will come up before the bench so that we can discuss the matter more privately. And when I mean more privately, I have a noise sound device that will be turned on, the mics will be turned off, and so no one on the panel will be able to hear our discussion. Now, first question is, except for failure to register, are you a qualified voter in this county and state under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question I always have to explain. I have to ask this question. We're not trying to prior to your personal affairs. This is just a question that we're required to ask by law. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? And that was my last question. Now, is anyone here disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay. This time we have one person. At this time, that's Ms. Walker Holloman. Would you please come forward? Attorneys. Let the record reflect that at this time, all those who are present on the panel are qualified. Now I will move to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just continue to remain seated. Now, I will ask these questions in the same manner that I asked the previous questions. That is, I will ask the questions, you can answer to yourself, and then once I finish asking the last question, I will ask if anyone would like to claim an exemption. And if you'd like to claim an exemption, just please raise your hand, and then we will ask you to come forward before the bench. First questions. Are you a person over 70 years of age? Do you have legal custody of a child or children under the age of 12? And jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period before today? Or are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? Now, if any of these exemptions apply to you and you desire to claim one of the exemptions, just please raise your right hand. Let the record reflect that no one on the panel is claiming an exemption. Now I'll move to excuses. With the excuses, I will make some statements, and if you feel that you would like to claim any one of these excuses, just please raise your right hand once I finish asking or making the final statement. A juror may be excused for observance of a religious holiday upon the completion of an affidavit as required by Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense or without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel desiring to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse. Therefore, all the jurors on the panel are qualified. They're not claiming any exemptions, and they are not claiming any excuse. Let the record show that this court is convened for the voir dire period in the case of the state of Texas versus Tyler Lindsey Connor. And today's date is April 11 of 2023. The time is 2:23 p.m. Let the record reflect that the counsel for the defendant, the counsel for the state, and all the members of the jury panel is also present in the courtroom. Good afternoon, ladies and gentlemen. I'd like to welcome you again to County Court at Law Number 2. My name is Judge Terrence L. Holmes. You have been summoned here to this court as prospective jurors in a criminal case. The defendant, Tyler Lindsey Connor, is represented in this case by his attorney, Attorney Dustin Galmore. The state is represented by its assistant criminal district attorneys, Attorney Kobe Hoffbauer
Good afternoon.
and Attorney Lamar Johnson. The court reporter is Mrs. Ada Christie. She will be taking down everything being said, so speak up when you're being asked questions or when you're giving answers to those questions. The bailiff in this case is Mr. Charlie Porter. The defendant stands charged by information with the offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. This is classified as a Class A misdemeanor. The punishment range for a Class A misdemeanor, if a person is convicted, a person can be given 0 days to 365 days, which is a year in the county jail. They could be given a fine from $0 to $4,000, or they could be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, backgrounds, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, please say so, and I will ask that you will come up before the bench so that we can discuss the matter more privately outside the presence of the other jurors, and I will put on the sound device. State, are you ready? Defense,
Right, Judge.
are you ready?
Right.
At this time, Mr. Hoffbauer, the panel is yours. You have 30 minutes, and the court will be taking, we'll be keeping time.
Thank you.
You may proceed.
Right, good afternoon, ladies and gentlemen. Right, we can do better, right? Hey, good afternoon, how y'all doing? All right, that's better, all right. Like Judge said, my name is Kobe Hoffbauer, all right, I'm an assistant district attorney here in Jefferson County, Texas. Okay. I am assigned to this particular court, County Court at Law Number 2 with Mr. Lamar Johnson. We're responsible for prosecuting misdemeanor cases, okay? County Court of Laws, this court and County Court of Law Number 3 prosecute misdemeanors. The next 2 courts over are district courts that prosecute the felony cases, okay? So our misdemeanors are Class B and Class A misdemeanors. As Judge said, this is a Class A misdemeanor we're prosecuting today, okay? What I'm gonna do with you during board hours, I'm gonna go over, ask some questions. I'm not gonna try to pry. If there's questions that you don't want to answer, I promise I'm not gonna ask personal things that you won't be able to answer. But should you, like Judge said, you can say, I'd like to step up and talk to the judge, outside in front of everybody else. That's normal. We do that all the time. Okay. Now I'm going to be asking some questions about yourself. I'm not prying, but I feel if I'm going to ask you questions, I'll tell you a little bit about me. All right. I'm a prosecutor. I was born and raised in Winnie's, Texas. I'm from Chambers County. All right. But I've been a prosecutor for 17 years. I've been a prosecutor in Hardin County, not Hardin County, Liberty County, Chambers County, Jefferson County, this is my second run in Jefferson County, and Bell County near Temple, Belton. Okay, but I've always been a Texas prosecutor, I've never been nothing else. All right, now, as far as the questions I'm gonna ask him, ask what you've done, you put a lot of that information on your juror information sheet, right? Might ask you some more questions about whether you served on a jury before, okay? We're gonna be asking you about criminal jury service, not civil jury, and I'm gonna try to explain the difference between those two things, okay? Everybody with me so far? Not asleep? All right, I talk loud, I know, I apologize, and I talk fast, so I apologize for that in advance. So do me a favor, if you can't understand what I'm saying because my accent or because I talk too fast, say, whoa, do that again. Come back. All right. I got tough skin and won't be embarrassed. I'm wrong. Now, what I know already before we get into it, we've got a whole bunch of teachers right here, or retired teachers in our front row. I'm excited about that because I'm the son of two teachers. All right. So they've got BISD. First of all, I think we have two BISD. Y'all know each other? Okay. Any of the teachers we know worked together before. That's just important, you know, if you know somebody, we need to know that kind of thing. All right? All right. Well, thank you for what you do, though. It's important. Thank you very much. All right. Now, what we're doing here is I work at the pleasure, so does Mr. Johnson. I work at the pleasure of Judge Keith Gimbel. He is the elected DA here in Jefferson County, Texas. That means we are assistant district attorneys to Judge Gimbel. I say judge because he was a former federal magistrate for a long time. So I still call him judge. Most of us do. Okay. But he is the DA here in Jefferson County, Texas. Now, Judge said we're doing here on the driving while intoxicated case. All right. Anybody first, when I first said that, what do you think about that? Pumphrey? What did you think when I said, when Judge said driving while intoxicated? What first came to your mind?
Under the influence of substance,
Okay.
such as alcohol.
Did everybody hear what Ms. Pumphrey said of substance like alcohol? Could there be other substances? What do you think, Ms. Lady? Drugs, okay, those kind of things. All right, intoxicated can mean under the, like you said, under the influence. Some states use UI, okay, driving under the influence. Texas uses driving while intoxicated. Okay, so we can prove that in many ways, whether it's the intoxication by alcohol and or a controlled substance, all right, or something, the combination of the two. You understand? And I'll show my age. I remember when I was only trying DWIs. Now it's a lot more, all right, there's a lot more substances out there. So the law has morphed and changed with the time. Everybody understand that? All right, now, in this particular case, what Judge said, we're talking about, this has been enhanced to a DWI greater than 0.15 or higher. So we're talking specifically with alcohol. Okay, that's something that the law has changed since I've even been a prosecutor. That has become an enhancement to a class A misdemeanor as opposed to a class B misdemeanor, which is what a DWI is without the enhancement. All right, so we're talking about a higher blood alcohol content when we say BAC. Okay, you're gonna hear some of that language. Now, during this, it's the only time I get to talk to y'all and y'all get to talk back to me. All right, once we seat the jury, I can't talk to you at all. Okay, so I'm gonna apologize for myself and Mr. Galmore that we can't talk to y'all outside. So if you see us, you know, if you make it on the panel, if you see us, we'll avoid you. All right, we can't ride the elevator with you. Can't do anything. I'm gonna trip over Mr. Galmore's cooler right here. Now, me and Mr. Galmore have known each other a long time. All right, we knew each other back when we were both at Lamar University. So we've tried a bunch of cases together. So you're not gonna have, as far as contentious, we're friends outside of this. Not gonna have a rip roaring fight. We might, but it's all in it's all our job. It's nothing personal. We've known each other a long time. We practice with each other a long time. Now, I'm gonna go over the elements with you, okay? The elements are what I have to prove beyond a reasonable doubt. Now, when I say I, it's the state. In a criminal case, the state has to prove each and every one of the elements beyond a reasonable doubt. Defense has to prove nothing, right? That's what is my job, okay? And if I don't find one of those elements that I'm gonna show you, what should be your result? This is Lewis.
Not good.
Exactly, not guilty. Why? Because the burden's all on me to prove the person guilty, right? But what do you think about that, Mr. President? How do you say it? Praise on, okay. I know Louisiana and Texas, two different things, man. So what you got? What do you think about it? Same thing. You agree? Anybody disagree with that? What Ms. Lewis, Mr. President said? Okay, now, I have to prove the defendant on or about a certain date in Jefferson County, Texas, did operate a motor vehicle in a public place while intoxicated. Okay, those are the elements I gotta prove beyond a reasonable doubt. Now, only the elements, what I have to prove beyond a reasonable doubt. Okay, that applies to the elements. And you notice up there, it doesn't say he was wearing blue shirt and blue jeans, right? Now, those may be facts in a case, and I'm giving you a hypothetical, right? Those may be facts, but those are not things I have to prove beyond a reasonable doubt. All right, you understand what I'm saying? Okay, those are the elements I've got to prove. In order, you'll find what Ms. Lewis said. What was that? Not guilty, right? Okay, now, I have that burden, it never shifts. That's my job, to prove the state beyond reasonable doubt. Yes, sir, Mr. Ward.
Can you define a public place?
I will. We're gonna go over that with you. Now, let me go through intoxicated first. No, first public place, okay, it will be, in regards to that is our public roads, parking lots in cities, those kind of things, all right? That's what the law says, okay? So like your driveway, what do you think? Private, right? Okay, so that wouldn't be something, somebody wouldn't pull, officers won't pull you over for driving intoxicated in your driveway. Now, what if you got off the main road and pulled onto your driveway? What do y'all think of that? What do you think about that, Ms. Walker Holmes? You give me that face like, I don't know about that. I don't know,
Yes, you caught me.
right? What do you think? What do you think about if you were on, like, let's give it like 365, all right? Right, goes through from that, comes to Needle, right? You're pulling off that onto your driveway. An officer pulls you over, or you operating a motor vehicle in a public place?
Yes.
Okay, why? What do you think?
Why were you?
Yeah, why? Well, you were driving on your road, right? Well, before,
Okay, ask me that again, why?
why is it a public place?
Oh, okay, the public road.
Public road,
I
exactly.
was gonna say,
Right.
did you get into a bar?
Yes, right. There you go. No. Well, you're right? You may have got stopped on your road, but you were operating.
Yeah. that you're going to-
Does everybody get that? Okay, Mr. Ward, does that answer your question? Okay. Now, intoxicated in Texas. Now, there's 3 definitions, all right? We're gonna go through these quickly because, not quickly, but we're gonna slowly do this because this is the gist of this, all right? This is what's important about these kind of cases, okay? Not having the normal use of your mental faculties by the reason of the introduction of alcohol and or drugs into the body, okay? Not having the normal use of your mental faculties, all right? Everybody got that one? Okay, or not having the normal use of physical faculties by the reason of the introduction of alcohol and or other substances into the body, okay? Drugs. Finally, having a blood alcohol concentration of 0.08 or higher. Now, anybody ever heard, I mean, who, first of all, let's ask it this way. Who hasn't heard 0.08 is the limit in which you can be operating a motor vehicle? You didn't know that much?
I was thinking point
0.4, okay?
oh,
04. Now, there used to be no level, all right? I mean, it used to be anything above, all right? But 0.08 is our standard, and it's pretty much the standard throughout most of the states, all right? That's the level in which it doesn't matter whether you're a drinker, all right, okay, or whether you're not a drinker. If your blood alcohol content is 0.08 or higher, you are intoxicated under the law. Want to get that? Meaning there's not, you cannot negate that somehow by saying, well, you gotta understand, I drink beer every day. I'm good at 0.10. That doesn't work, okay? 0.08 by law is intoxicated and everything. Everybody understand that? Okay, now, why do we have 3 definitions? What do you think? Ms. Miller, what do you think?
You need all of those to be able to drive.
Okay,
Able to think and move and.
perfect, that's the best answer I've ever gotten in 17 years. That question. That's the best answer I've ever got because you need all of those, right? Because you need to do that. Why do you need all those? Will? Come on, put-
Operate the machinery.
Exactly. What is a vehicle? It's a 1,500-pound missile, all right? But because if you're not operating, you don't have your faculties, what can it do? Exactly. all right? I don't have to go into that, right? We know what they can do, okay? Now, so you need both your mental faculties and you need your physical faculties, all right? So I'm gonna go through this example with you. Now, the biggest misconception about a DWI case is, well, what do you think was done? Just, first of all, there's no right answer or wrong answer. We're just talking. Okay. Well, what do you think, Mr. Ward? Do you think what about a person has to be drunk? Does that sound about right or wrong?
Partially right.
Partially right. Drunk is slang, right? You have to be drunk. Well, it's not really, that's not what the standard is in the law, okay? You have to be intoxicated, okay? That's why we got those definitions, right? We got those specific definitions of not having the normal use. Now, I asked you about why we had three. Ms. Miller gave the best answer. I'm gonna write it down. It was a great answer. But we have it because we'll give you this example. Now, this might date me. I apologize. This movie. Okay, anybody ever seen this movie? You know what movie I'm talking about. All right, Mr. Hill, you do?
Yes.
What's it about?
Well, it's about a college, a couple of fraternities and maybe the nerds running a fraternity.
And they started their own fraternity, right? The Lambdas and the Alpha Beta.
And there was a lot of debauchery going on.
Yes, very, we won't talk about it in specifics, all right? We're just gonna use the people in it, all right? So Lewis was the leader of the Lambda. Not calling him a nerd, he was called a nerd then, we won't do that, none of that now, okay? Now, Ogre was not, right? Ogre, what do you think about Ogre in regards to what Ogre's drinking ability was? Mr. Jacob, what do you think?
Never watched it.
I never watched, well, I mean, just looking at Ogre, what about just a picture of
Or the end.
There you go. So what's Ogre's tolerance for alcohol, you think? Pretty high, right? Okay. So we're gonna use that example, okay? Now, okay, so we got Lewis, 145 pounds. He's never had a drop of alcohol in his life, okay? He has 2 glasses of champagne. His speech is slurred. He's poor balance, all right? Now, he's making improper comments that he would never say, all right? Now, his mental and physical faculties are not normal, but his blood alcohol content is below 0.08, right? Now, what do you think about Lewis? Is he intoxicated? Now, just don't answer, but think about it. Is he intoxicated under the law of the state of Texas? Okay, now let's juxtapose it with Ogre. He weighs about 250. He's a champion drinker, all right? He's been drinking since he started shaving, okay? Now he has a very high tolerance. Now he acts just like he does when he's sober and not a drop, right? Even if he's had 2 kegs here, okay? Now, but his blood alcohol content is way above 0.08. Everybody with me? Now, which one is intoxicated under the laws of the state of Texas? Let me see, Mr. Blitz. Ogre. Okay, what about Lewis?
Can't handle with alcohol, he's, which is basically, because he can't handle with alcohol, that's where you would label him as drunk.
Okay, but also there's 2 definitions of not having the normal use of those mental factors. I mean, he's saying things he doesn't usually say, right? Also, he can't balance, right? He's having trouble walking. Maybe because it's the first time he's felt that way. See what I'm saying?
I'm not saying he can't be prosecuted.
Okay, but would he wouldn't be intoxicated or would he, what do you think?
Under the law, he's not, because he's under 0.08.
Okay. Now, everybody agree with that or disagree with that?
Disagree.
Okay, what do you, Mr. Valenta, is that right?
No, but he's mentally affected, and as I've warned patients, sometimes who get legally prescribed medications, you can still be intoxicated whether you're on alcohol, on a legal drug or not.
Okay, so, and there are warnings on, like on medications, we have warnings, right? But it would affect you, right?
Correct.
Anybody who disagree, who also had their hand up, if I missed you? You had something with somebody else? I thought somebody else.
I said that I disagree that he
Okay.
would not be able to be prosecuted
Okay, why's that?
because he falls under, what's his name, the little guy?
Yeah, Lewis, yes,
Lewis
sir.
falls under the physical and mental capacity. While
Exactly,
Ogre's blood alcohol, the other one's alcohol.
is above. Now, Texas law says neither one of them should be operating a motor vehicle on a public road. Okay, neither one, right? Now, whether or not to be prosecuted or not, for sure, you understand, like, we don't pick and choose the prosecution, it's just whether or not they met that. Now, I heard somebody over here talking, it said 2 out of the 3. Who was that? Anybody? All right, Mr.
I didn't know. It
Oh.
have to be 2 out of 3 or all.
Okay, now here's the deal. That's common misconception. It's not 2 out of the 3. It's 1 out of 3. All right, so if you lost the normal use of your mental faculties, but you didn't lose the normal use of your physical faculties or your blood alcohol was below, you're still intoxicated because it's 1, 2, or 3. Everybody get what I'm saying? Now, it's also important, and this is a wrinkle in this, but you need to understand, like, if you make it on the jury, there'll be 6 of you. At the end of this, at the end of a DWI trial, I'm just talking about a hypothetical. If 2 of you think that the person lost the normal use of their mental faculty, let's say 2 of you think that his blood alcohol content was above a 0.08, and then the last 2 thought he lost the normal use of his physical faculties. That's sufficient to find someone intoxicated. It doesn't have to be unanimous about which one of those definitions there are. Okay, that's not a requirement of the law. Everybody, and that's a different thing, but that's the way the laws apply. Now, anybody, it's okay to be uncomfortable with the law, all right? But we need to know, we gotta talk to you. Anybody have a problem with that? Thinking, well, that's just too wide of a net and somehow somebody's gonna get caught. Some people think that, right? And it's okay if you do. We gotta know. Does anybody think that? That's just too broad of a net in regards to what you can prove intoxication. Everybody's okay with that? Everybody understands that? It doesn't have to be unanimous about which one it was. It doesn't have to be, you have to 1, 2, or 3. Well, he didn't prove the last one, so it can't be. No, it's just one of those. It's not a culmination, right? It's not 2 out of 3, not 1 out of 3. It's any one of those. Okay, Mr. Martinez, you're looking at it laughing like, I don't know about all that. I don't like that. What do you say? What do you think?
Agree.
You agree? Okay, all right. I'm just asking you, I gotta talk to everybody, all right? I'm not trying to pick on anybody, I promise, okay? Now, we've gone over that, we've gone over the 3 definitions, that's the most important. Now, I always ask this, like, anybody know anybody who was falsely accused of DWI that were sober as a judge? And they got pulled over and charged with a DWI, anybody know that? Okay. Take by your silence, no hand, nobody has, okay? Now, what about somebody that's been hurt or injured from the cause of an intoxicated driver? That's an important question we have to ask. Anybody know anybody personally or? Okay, Mr. Ward, we're going this order. Juror number 8, Mr. Ward. Can you tell me a little bit about that, if that's okay?
My daughter went out with her fiance to have drinks and they got a lift for Uber.
Yes.
And so, they knew they would be drinking. And they drove home and the Uber driver had a head-on collision with a truck that was driving down the street.
Yes.
Fortunately, her driver come to a complete stop and the other car was going about 35 and they hit. It broke her ankle in 2 places and had a plate and 6 screws put in it. It's been a little over a year now. Still, she can walk. Now she has to have surgery back again, return for surgery. And move the plate.
Well, and I'm sorry that happened, and I appreciate you talking about that. Now, important the question is, and I'll ask you, Mr. Owen, is due to the fact that you have that experience, okay, with your daughter being struck by an intoxicated driver, can you still put that aside and be a fair and impartial juror? Take this case strictly on the facts presented in the evidence. Can you do that? Okay. That's okay, and I appreciate Mr. Ward, and that's what we asked the question for. Thank you, so appreciate that. Ms. Stone, would you tell me a little bit about?
Yes, it's about 30 years ago when I was 18, one of my classmates, my teacher, son and his friend went to Louisiana for a club because they can drink at the age of 18.
I think I know that.
Yeah.
Yes.
So home, his friend was already drunk, but they still want to drive home. And while they were driving home, his friend hit the 18-wheeler in the back, which caused the passenger tied to, which is her son, to be handicapped. He lost half of his face, his body, I think he lost his arm. He was in a rehab for over 2 years. He had to have structural face surgery, a lot.
Like a reconstruction.
Reconstruction in the face and everything. They went through a lot from his incident. At times,
Yes, ma'am. Yes, ma'am. Now, having that, not you as the experience, but knowing about that, do you think you could set that aside, be fair and impartial, and with the law, not have a bias, and listen to only facts that are presented in this particular case? Did you do that, ma'am? Thank you. Yes, sir. Thank you, Ms. Stone. Everybody here, Ms. Stone said, Mr. Ward said. Did anybody else have experience, Ms. Lewis?
I just had a former student
Okay.
killed.
Killed by drug driver. Now, I know that was tough for y'all to handle, and thank you for talking about it. I mean, do you think you could put that aside? Same question I asked the other year. You could be fair and impartial. And I'm gonna ask everybody this, could they be fair and impartial? Set it aside and just listen to the facts presented in this particular case. Good, thank you. Anybody else? Yes, sir, Mr. Let me make sure. Mr. Lee?
Yes, sir.
Okay.
So, good buddy of mine, that's away from drunk driving, they don't.
Hit on. I'm sorry that happened. And I apologize. And I thank you for speaking up about it. I'm asking questions I asked the other jurors. Could you be fair and impartial, even though you lost a good friend? Yes, sir. You can put that aside and just listen to the facts and the evidence. And this. Thank you, sir. Now, anybody else? Yes, sir, Mr. Blitz.
Both sides, both ways.
You've had both ways.
Just because of my.
Yes, sir. Now, you're a retired officer, is that correct? Now, was your wife Miss Nancy Blitz? I worked with Miss Blitz a long time with, and his wife worked at the farmhouse. And retired from that. So thank you, y'all, for your service. Now, so, but you could put those aside, your work prior, you're a retired police officer, correct? You can put that aside and listen just to the facts of the case.
Yes.
Right, and be fair and impartial. Thanks, sir. Okay, anybody else? All right. Now, ever been around anybody who's intoxicated? All right, let's see, Mr. Baker. You ever been around somebody intoxicated?
Yes.
All right, what do you notice about them, or what do you notice about
No, at least I don't speak so well.
them? Okay, what, the slurred speech?
Yeah.
Is that fair?
Yeah.
Okay, what about, you see, Mr. Martinez, what else, besides slurred speech, what do you notice about somebody?
Stumbling.
Stumbling, not really steady on their feet, maybe? Okay, now what about, and Mr. Womack? Okay, what about something else? Think of something else?
When a person's intoxicated, it kind of amplifies whatever's going on
Okay,
if they're aggressive.
okay, so, no, and I'm gonna make sure I want to get it right. What Mr. Womack saying is that whatever, I guess, you know, their behavior, is that right? Like if they're aggressive, they may be more aggressive, is that right?
Yeah.
Okay, so if they're, you know, if someone, for example, some of them mean drunk, you ever heard that line?
Yeah.
A mean drunk, somebody who's fine, but when they get drunk, everybody's the enemy and they want to fight everybody. That, y'all heard that? Okay, it changes you, right? Or it amplifies, correct? Anybody disagree with that? Okay, what about quiet drunks? What about people that get intoxicated and then all of a sudden they talk a lot like me, like talk fast and then they don't talk at all? Would that change them? Right? Okay. Now, so is it fair to say that any kind of clues, like there's not a strict number of clues that will be shown in every person. Every person is different.
Mr. Hopper, you have 5 minutes unless you need more time.
I just need a little more time to.
Okay.
We're on intoxication. You understand what I'm saying in regards to that each person has their own signs or may show signs of intoxication or not being intoxicated. Doesn't mean that's the reason, right? Okay. But now, how did you know they were? Let me say, okay, I want to make sure. Mrs. Humphrey. Okay. If you've been around someone intoxicated before, how did you know?
they're different.
Okay. Okay. Everybody disagree or agree with that? Right, Miss Miss Williams, do you think something else that hadn't been said in regards to somebody like that? What about odor or smell?
You can always smell the, you know, the wood coming from the liquor.
Okay.
And I also think it kind of gives them a little bit more courage to say things that they normally wouldn't say, so it goes to behavior.
Exactly. Hey, you ever heard 10 foot tall and bulletproof, right? All right, that's a good example of someone that, right? Is that fair, Trish? Okay. Anybody anything different? All right, I'm gonna move on. Now, so we've gone through smell, balance, speech, judgment. What about judgment? Does that go with yours and Ms. Williams? Like, think that, hey, you're bulletproof, right? You do things you wouldn't normally do, right? Because why? Are the consequences right on the, you know, are you thinking about those at that time? Generally not, right? Okay. Actions. Now, none of these signs require you have any kind of prior expertise. Okay, you don't have to be a former officer like Mr. Blitz. Okay, you have to have what? Common sense. All right. Did y'all check your common sense at the door when they checked for metal and all that kind of stuff? You put it in a common sense box? No, you didn't, right? That's why you're here. That's the point of having a jury of the community determine these cases, okay? So you don't have to have any expertise in this particular kind of thing. You just have your common sense, and all of you have it, all right? And all of you are certainly qualified to sit on a jury, okay? Any kind of criminal jury, right? Now, what would you like to see in a DWI trial to determine if someone's guilty? What do you think, Mr. Jacobs?
Evidence that they were intoxicated.
Okay, what kind of evidence would you think? What about, like, what officer has?
Well, I mean,
Okay,
you said you gave 3.
true. What about, go ahead, Ms. Stone.
Blood work,
Blood work, if it's, we're talking about a blood alcohol content, so we have to have blood work, right?
I think they blow,
There's a breathalyzer test. We have those particular things, right?
they're for the testing 1, 2.
Oh, yeah, the
ABC.
field sobriety test, I think that's what we're talking about. Is that right?
That was it.
Okay. Now, video,
Video.
right? Officers have video, body cams, also they're in-car video, okay? Now, field sobriety test, we talked about that. Now, why do you think we do that, Mr. Holmes? Field sobriety
See
test.
how fast or how slow they corresponds to the action sometimes, you know, if you're driving and intoxicated.
Yes, sir.
You go on 30, you feel like you're going 65, but if you were normal, you still going 65, you can feel like you're going 65.
And it's maybe you've got to be more careful with that. Like fair? So like they're divided attention tests, okay, field sobriety. And why are they used? Because driving is a divided attention. You have to use your mind, also your actions. Okay, controlling the steering wheel, your gas, the brake pedal, those kind of things, right? And if people have driven a manual, we were all taught to drive manual before, but I don't even know if they have those anymore, so you have to go through that. All right, but obviously you need your mental and physical faculties to do that, right? Good. Now, divided attention, 2 seconds late on the brake means you might rear end somebody. These are examples. Turning a steering wheel 1 inch might mean you sideswipe somebody, right? These are very small things that we do every day, but if you don't have your normal mental and physical faculties, they're big things, right? Good. Now, testimony, that's evidence, okay? Testimony of an officer, okay? Testimony of witnesses that may be out there, okay? All of that's evidence as well, all right? Now, blood test, we talked about that, blood work. Now, we said here, everyone's ability at 0.08, it's not whether or not you're a drinker, your tolerance has nothing to do with it. 0.08 is the limit, all right, by law, okay? Everybody understand that? Anybody disagree with that? Some people disagree with it, maybe saying they should be lower than that.
think if you got a commercial driver's license, it's 0.04.
You should 0.04? Okay, that might be whether or not you keep your license. Is that fair to say? Okay, and it's not in regards for a DWI. We don't have a lower. However, some as far as some jobs and some certifications, may have a higher standard, right? But in regards to the laws and criminal laws, it's a 0.08 is the standard. However, CDLs, which is the commercial driver's license, they may have a lower standard. And that's due to whatever union or agency or, that they require. But 0.08 is what we have for criminal law. Everybody got that? Understand? Okay. Now, everybody, CSI, NCIS, all whatever cities they have. Everybody like those shows? You like them? Come on, raise your hands. Get your hands up. All right, investigative discovery. You watch those, one murder mystery after another, 1 hour over and over again. Right. Now, everybody understand that's television, right? Television, right? Television is our reality. Even though I wish that we had that, if we did it that or the criminal justice system work that fast. Okay, it doesn't. All right. Now we have what we have to do. We will show you for sure. Okay, with some of those machines and some of those tests that just made up. All right, or Quantico's got it. That's reality. I'm not Jefferson County. Okay, but that doesn't mean somehow that limits what I have to prove to you. Those elements that I'm to prove. Everybody got that? Okay, I wish it was like that, but it's just not. All right. Now, burdens of proof. State's got to prove a case beyond a reasonable doubt. All right, that's the highest burden of proof we have. Okay, now, all burden of proof is common sense. Y'all didn't check it out the door when we went over that. Is that right? Everybody's got it. Everybody can do this. All criminal trials in the state, in the United States, use this. It's done every day. All right. It's not insurmountable. It's important. It's not impossible to meet. It applies only to the elements, like I talked about at the beginning. Now, let me go with this. Who haven't we? Jacobs. Right? Yeah. Okay. Mr. Jacobs. What about looking at up there? What do you see? I'm not Hill, but. Oh, Hill, sorry. Mr. Hill. Sorry, Mr. James. Okay. You see a puzzle, but what is it? What's the image? There is a pistol. Okay, gun, right? Now, does everyone see it's a puzzle with a gun? Right? All right. Now, is it missing pieces? Yes. Right? But can you not tell what that puzzle is? It's a gun, right? Do you think it's an elephant? Is it a river? No, it's a gun, right? This is just like a trial, okay? Every evidence piece becomes a piece of the puzzle, okay? So, may not have every single little piece, but there's enough evidence to tell what it is. And that's kind of an example of how a trial works, okay? Now, reasonable doubt. I can't tell you, Texas law requires I believe each and every one of these elements beyond a reasonable doubt. Now, they used to be able to, long before my time, where they could give you a definition of reasonable doubt. I can't anymore, okay? The courts won't let us do it. I can't tell you what it's not, okay? I can tell you it's not beyond all doubt. Okay, why would it not be beyond all doubt? And this is Boyd. If it was beyond all doubt, like you saw it with your own eyes, could you be on the jury? Why not? You have to be a witness on that box right there, not the big one, but the little one, right? So you couldn't be a juror if you're a witness, right? Okay, so it's not beyond all doubt. What about not beyond a shadow of doubt, Ms. Laser? Yeah, that's a Matlock term. That's not a real term, like. Yeah, right, yeah, but that's a TV term, right? That's not the law, okay? It's not, the shadow of doubt is just a TV term, okay? So, best way to explain it is you'll know when you see it, all right? You have common sense. All you need is common sense. You didn't check it out the door, you got it, and all of you are capable of doing that, okay? Now, I'm gonna move along. Prior criminal jury service, really quick. Who is here served on a criminal jury? Anybody? Mr. Baker, what kind of jury was that? If you don't mind telling me.
It was a murder trial.
A murder trial, was it here in Jefferson County? Okay, and about how long ago was it?
4 or 5 years.
Okay. Did y'all administer punishment or do anything like that? Okay, and is there anything about that? A murder trial is very serious. Thank you for your service for that. Anything about serving on that particular jury that will keep you from where you couldn't be fair and impartial in this particular case. But thank you. Everybody, anybody else in regards to the criminal jury? Okay, now, some of y'all said y'all served on a civil jury before. It's different, all right? You need to understand, civil juries is, first of all, it's about money. All right, it's about money. Criminal jury is about something totally different from that, all right? But the burden of proof is preponderance of the evidence, just means a little bit more likely than not. Everybody got that? Okay, ours is beyond a reasonable doubt. It's the highest standard. Okay, now. Important. I ask this question to every juror I have, and I'm gonna tell you why I ask that, because it is important, even in this kind of case, all right? Anybody who cannot sit in judgment on another person in the context of the court. Anybody. I'll tell you why I asked this question. About 8 years ago, I tried a sexual assault of a child case in 2 courts over, right? We went through a full trial. We had 10 witnesses and we went through a full trial, and during the deliberations, excuse me, I didn't even say that word, deliberations, one of the jurors came out and a note came out and said, due to my religious beliefs, I can't sit in judgment on any kind of case. Well, what happened then? Mr. Blitz, what happened?
One of the substitute jurors or
The mistrial. Because it's a criminal case, right? So that means, that's why, and I asked this question in the board hour in that particular case. But they didn't answer. And then when it came down, that's what you do. Now, I'm not saying that if their religious beliefs, that's perfectly fine. But we got to know right now. Can't learn later. And in that case, obviously, we had to do it over. We had to put that victim in, do that again, and go through the full trial again. But it's important, even in this, to know that if you can't sit in judgment, that's what sitting on a jury is. Now, it's not sitting in judgment of anything higher than just what we're talking about, okay? Your religious beliefs, we understand that, and you just have to let us know now. We can't find out when it's deliberations. You see what I'm saying? Does anybody who have a problem sitting in judgment? Everybody okay? Okay. Now, look, your duty as a juror is to decide the fact. You decide what happens. You hear the evidence, you hear testimony, you hear all of that. You decide what happened. The judge is going to give you the law. Okay, he's going to give you what we call a jury charge. He's going to give you that law. And you take the facts that y'all decide on, who's ever on the panel, you apply the facts to the law and you follow the law. That's it. That's it. Now, if I haven't asked anything, and I'm not perfect, so if there's something that y'all are waiting to answer, or you wanted to tell me about something, like this time is the only time I get to talk to y'all, like I said before. If there's something I didn't ask, if y'all got any questions for me, I can't answer them after we sit down. So is there anything else y'all like to ask, or something maybe I should have covered if you wanted to talk about? Thank y'all very much. Oh, yes, ma'am. Excuse me. Just my phone.
How soon will this take place?
Right, we'll start tomorrow afternoon. Testimony.
And what is the expected length?
No longer than a week. No longer. That's the only thing that we give up. Is that fair to us?
Yeah, I don't know how many witnesses you have in there.
But we expect no longer than a week. Okay. Hope that's the best I can do. So.
I may need to.
Okay, we can talk if you need to talk. No problem. Anybody else like Ms. Pumphrey that may need a problem with it if it goes more than a few days? Everybody okay? Thank y'all so much for your attention and your patience. I appreciate it. Thank you.
Okay, Mr. Hopper, you took 41 minutes. Mr. Galmore, you have 41 minutes. You may proceed.
Try to go quicker than that.
Okay.
Thank you. It's clear. Yeah, there you go.
All right, good afternoon again. My name is Dr. Gallimore. Attorney here in Beaumont. And I represent Tyler Connor. He's also a resident here in Southeast Texas. And we're looking forward to presenting this case to you. I'd like to ask a question. I want everybody to think about this. It's a very serious question. Is kind of whitewashed there, but who's excited to be here? See a couple of small hands there. I saw you sort of raise your hand there. Is that Miss Lewis?
Yes,
Are you excited to be here?
can't wait.
Yeah. Tell me, why can't you wait? What are you excited about?
My students are really anxious to find out what happens in my life.
Okay, okay. Are you looking forward to experiencing a trial and you can go back and talk to your class about it?
Yes, I teach American history,
Americans, what school?
Kelly High School.
Okay. Who else raised their hand? I saw the lady there in the back. Is that Miss Bourgeois? No. Okay, Miss Boyd. So, tell me, what are you excited about?
Jury duty.
Never been on jury duty before. What do you do for work?
Sales representative.
Okay. Is there anyone else here that's never done jury duty before? Couple of hands, okay, interesting. Mr. Creedy, are you excited about it?
I get to miss work.
Well, that's good, right? You still get paid?
Yes, sir.
Okay, perfect. What about you, Miss, is that Dolman?
Yes, I tried to avoid it. I tried to answer all the questions, also not to get paid.
Well, that's a good tie into, my next slide. First of all, what kind of person would you want on your jury if you were in trouble in this court right here? Who would you want on your jury? I don't know if y'all remember Michael Vick got in trouble for dog fighting. Does that look like a very fair jury for Mr. Vick? Not really, does it? So back to what you said, this is a deselection process. So we're not here to actually pick who we want as our jury. We're here to pick who we do not want on our jury. So each side will get a few strikes and we'll decide we handle with this person or with this person. And then we're gonna have to, take whatever's left over. But if you see that guy right there with the big mouth, he's talking a lot, he's gonna be the guy that gets struck, right? Because if you don't say anything, then we don't have any reason to say, hey, I don't like that person. No, right?
Learned that from my mother.
What did you learn from your mother?
She would go and some man got up and spoke and said, he said what I thought, and she thought, I'm so proud of him. Tell her they picked it.
Say pigtail. Oh, well, here you go. Well, we won't have as much information to go on if you don't talk, so please feel free to share all of your thoughts. Does anyone in the courtroom know anyone else in the courtroom? I think it's been asked yet. Another juror? Okay, I see you raising your hand.
Met Mr. Hoffman.
Met Mr. Hoffpower before, okay. Anyone else in the courtroom? Okay. Does anyone else in the courtroom know any of the attorneys or the judge? No? Okay. Oh, we have a hand back here.
I know, Ms. Holland, yes.
You have a comment? Okay, how do you know each other?
Same sex sorority.
Okay, awesome. There you go. Just like, what, 5 or 10 years ago?
Actually, I'm a 3-year person and she's, yeah, no. That many, so she saw me and I'll say that.
Okay, that sounds good. Well, this is a loaded question here, and this picture is kind of a loaded picture, but is there anyone here that says, you know what? Innocent people never go to jail, never are behind bars. Innocent people are never convicted of a crime they did not commit. And so it happens, right? On occasion, hopefully rarely, right? So what are some of the ways we get it right? What are some of the ways that a juror or a jury can make sure that that doesn't happen? And the way is there are certain constitutional provisions that we have in America that no other country has, which makes our judicial system, even though it's not perfect, probably one of the best, if not the best, in the entire world. So one of the ways is the presumption of innocence. I'm sure you've heard of it. Like see that or hear that on TV or the news. Presumption of innocence means everyone is presumed innocent. So right now, if you as a juror had to vote on whether Mr. Connor is guilty or not guilty of this offense, how do you have to vote?
Not guilty.
Not guilty, right? He's presumed innocent. And that presumption carries through until the end of the trial. So no matter what you hear, what you see, the presumption stays until you're in the back and you're deliberating and considering the evidence. So should allegations be proven? Should allegations be proven? Of course, right? So there's about 5 or 6 allegations in this case. That Mr. Connor was driving a car, that it was in Jefferson County, that he was intoxicated, and whatever the other elements are of the offense. Each one of those has to be proven beyond a reasonable doubt. This is an example or kind of a chart of standards of proof in Texas. You've probably heard of probable cause. Probable cause is when an officer needs to arrest someone out on the street. He doesn't have to prove it beyond reasonable doubt, right? He is probable cause to believe a crime was committed, and so he can make an arrest based on that. Preponderance. Preponderance is when you sue someone for money. Car wreck scenarios. That's a 51 to 49. Preponderance just barely in favor of, and then you're the winner. Clear and convincing is what they use in family courts to take kids from their mother. There's no real definition, but a firm belief that the allegations are true, the evidence is clear and convincing, and that's the case. And then a reasonable doubt. And a reasonable doubt is really not complicated. If you have a reasonable doubt about a case, well, then the verdict is not guilty, right? If you have any reasonable doubt, it doesn't really matter what that reasonable doubt is. So that's a picture of a mother. I assume, she's being separated from her family, and one of the things I'd like to ask each of you to think about, if you were affected by a case where a mom was going to lose her children, maybe it's your daughter's going to lose her children, or sister's going to lose her children, how sure would you want the evidence to be? How strong would you want the evidence to be? Let's say on a scale of 1 to 100, Miss Pumphrey, how certain of the evidence would you want to be before you would allow the government to take someone's kids from them? You'd want to be absolutely certain, right? Miss Leger, is it Leger? Leger. How certain would you want to be on a scale of 1 to 100 before you'd allow that to happen?
I'm saying
100?
Okay.
There's no right or wrong answer. There's no right or wrong answer. Who agrees with Ms. Leger that maybe not 100, but it should be really, really high before the government should be able to take those kids from it? Does anyone say, hey, you know what? I think a number around maybe 80% sure would be good enough for a situation like that? Anyone? I have a gambler in the courtroom. Who's my gambler? I'm not a gambler. I always lose, so it kind of rubbed me on gambling. Okay, I'm gonna go with you, Mr. Sorry about that, Mr. Ward. Okay, so let's say right now you have to put $1 on the table, coin flip, double your money or lose your money. How important is that bet to you in the grand scheme of things? Yeah, $1. Not that important. Would you lose any sleep if you lost? No. What about $100? Not too important. might wish you would have won, but you're not going to lose sleep over tonight, right? How sure of that bet, that 50-50 bet, would you want to be able to put up half of your life savings? You wouldn't even make that bet. Why not? Too much to lose. Would you want to be more certain than 50-50? The coin flip, in order to put something like that up. Is there anyone here who says, I put up half my life savings for a 50-50 coin flip? No? There was a time in my life I would, because I didn't have a life savings, but hey. What about a night in jail? $1 bet. If you win, you get another $1, and if you lose, you spend a night in jail. How's that sound? Shaking your head, no, I'm not gonna do it. No. What about a year in jail? How sure of the evidence would you want there to be, or how sure of the odds of the coin flip would you want to be before you would consider spending a year in jail on a bet? 99.9. In this case, it's a class A misdemeanor. The law allows punishment up to 1 year in the county jail. Now, I would like to think that that wouldn't happen in this case, but the law allows that as punishment. It's very serious, but not only jail time, there's other consequences. Miss, is it Miss Walker Holloman?
Oh,
And you're an educator,
yes.
and I saw that you have a postgraduate degree, correct? Maybe you saying that? Well, there's several on here that have. I couldn't remember. How do you think criminal record would have affected you in your career? Wouldn't have a career. Criminal records are on the internet these days, right? They follow you forever. Is there anyone here that thinks, criminal record's really not that important? Of course not. So even though jail time may not always be a possible outcome, criminal record is, right? So this is a principle that could possibly come up in this case. As an example, there's a blood evidence, I suspect, could be introduced in this case, could be introduced in any DWI case. And one of the principles in the Code of Criminal Procedure that the judge may instruct you on at the end of this trial is what I call 3823 instruction, because that's where it's found in the law. What it states is if you as a juror, if you believe or if you have a reasonable doubt thereof that the evidence was obtained in violation of the provisions of this article, then you shall disregard the evidence that's obtained. Okay. And so I try to give an example of how that principle might apply. Is that a blood test case, if you find that the officers broke the law, right, in obtaining the blood, then you're supposed to ignore that, but only if you find that the officers broke the law in obtaining that. Does that make sense? Okay, so it might sound simple, right? Maybe you really wanted to consider that blood evidence. Maybe that blood evidence shows that someone's way above the legal limit. But with that instruction, and you believe the officers did in fact break the law in obtaining that blood, you would have to ignore that blood test result. Does that make sense? Does anyone here, by a show of hands, say, I can follow the law and I can do that? Okay, is there anyone here that says, you know what? I can't follow that law. I am not going to ignore evidence that shows someone's guilty. Is there anyone who feels that way? And it's okay if you do. Okay, we have one hand, Mr. Ward.
How can it be introduced if it's illegal?
There are two parts to something like this. There's a court ruling and then there's a jury decision. And we're only here talking about the jury side of that right now. But you'll receive instructions on how that may or may not apply with the court. But more importantly is that if that duty is put on you as a juror, you have to make that decision. And you do in fact make that decision that the police did in fact break the law in obtaining that blood. You would have to then follow the law and say, I'm going to ignore that evidence. Can you do that? Okay, yes. Does anyone say no? I can't do that. Now, we'll make it a little more complicated. It's not a murder case. But imagine you are in a murder trial. And imagine that evidence that you now have to ignore is the dead body in the trunk. Or maybe that evidence is in the trunk is a kilo of fentanyl that is probably going to go out and kill all kinds of people out on the street. Same legal principle applies. Is there anyone who says, you know what, with that heightened scenario, I don't know that I could do that anymore. Yeah, maybe. It's a little harder, right? Dead bodies makes it a little complicated. Luckily, there's no dead bodies in this case. I'll tell you that right now. Okay, so you're all off the hook on that. So the law says that you have to be a left-handed writer to be on this jury. Miss Lewis, can you do that? No. So if you have a thought or a belief that you're not fit for this jury, that's okay. Just let us know. There's a different trial probably that's better suited for you. Let's see, there's a couple of other questions. Miss Leisure. You're retired?
Yes.
From where?
We don't independent school.
Okay. How long were you teaching? What grade?
Speech therapist.
Okay, speech therapist. Thank you. Okay. A lot of school teachers. Okay, Mr. Jacobs. Mr. Jacobs, you retired?
Yes,
What did you do for a living, if you don't mind me asking?
I was a supervisor in the chemical plant.
Okay, are you, engineering background or chemical engineering background? Process operating stuff more or less? Or dealing with that side of it?
Process operation.
Ms. Wilson, Ms. Williams?
Yes.
Retired from the post office.
Post office of the United States military,
Oh, interesting. What military branch?
army,
US Post Office, how long were you there?
12 years,
Beaumont,
yes.
ULG? Mr. Slider?
Yeah.
Me and Mr. Slider were on the bowling team together for several years. And his lawyer, his son's a lawyer now. I really run into him every once in a while.
I can think of it.
He passed last year. He did. That's what it is. Here, one more. Let me ask this question. It's always fun in the DWI job. Has anyone ever had a drink and then driven a car before? Okay, most people raise their hands. Who do you, raise your hand if you think you've had the most to drink and then driven a car before, out of everyone in the jury box. Yeah, we got a couple of hands. Let's go with you, the brave hand raisers here. Is that Mr. Friedman? I'm sorry, one more row back. Mr. Baker? Mr. Baker? Okay, so, first thing, let me ask you is, how many drinks do you think you had before you drove a car?
Good meeting.
Too many. Did you think it was safe at that time? Do you think it was safe now? No. Did you get pulled over?
I have been pulled over.
Have been pulled over? Okay.
I'm not thinking of it at the same time.
Anyone else want to volunteer at a time where maybe they've had too much to drink and then drove home? Ms. Dillon?
Yeah, my husband and I went to a party. We always have a designated driver, so my husband decided that he'd be the designated driver. Okay, it's my time to drink. Well, he got excited and he drunk too. So we both got drunk. And he said, "Babe, I can't drive. There's no way I can drive." He said, "No, I can't drive either." He said, "Well, someone of us has to drive. I don't think you should have." I said, "I don't think I can drive." But okay, we go in this inside road and drive our town slowly, but we make it home. I did drink, but I don't drink a lot. When we go out, I'll be the designated driver. But that night, my husband said that I can drive, so.
So it's his fault, really.
Yeah, it's his fault if we didn't get caught.
Did you have access to a breathalyzer before you drove the car?
No, I know I was drunk, cause because I drink too much. I know my body cannot function well enough, but enough to drive home safe. If find a way that there's no car. I know my route to go home, that there's no car, not a lot of traffic on that road, so that I don't mess up anybody's life. But, and pray at the same time, but we did make it home. Yeah. And I told him, never, ever again, no.
Well, that's good. What about you, Mr. Ward? Were you able to test your blood before you left that day? Did you have a breathalyzer? I guess so you just had to assess the situation as it is without knowing your blood test result.
Baker.
Oh, I'm sorry.
Okay.
You're right, Mr. Baker. Yeah.
No, I did not have access to a blood bank.
So as that slide says, I think Judge said it earlier, if there's something that now after the state's gone and I've gone and we talked about a few different things, if there's something you think, you know what, I wish someone would ask me about this, or there was something I thought I should share, and I just had an opportunity, we can do after it's over and we can talk about it. Or is there anyone that thinks maybe there's one more thing they would want to talk about? No? Okay, well, your job as a juror, if you're elected in this case, is to rule out every reasonable doubt before you can return a verdict of guilty. So everyone's promised they can do that. They can rule out all reasonable doubt before they find someone guilty. Okay, thank you.
Okay. Ladies and gentlemen of the panel, we're gonna ask that you step out into the hallway. We may have to call some of you back in to do some follow-up questions. At this time, you will follow the bailiff into the hall.